Okay. Welcome, everybody. My name is Robin Gross, and I'm the policy chair of the San Francisco Bay Area Internet Society. It is my pleasure to welcome you to this edition of our chapter's monthly tech policy webinar series. Today's topic is on the implications of a recent U.S. Supreme Court decision in Van Buren v. United States regarding the reach of a federal anti-computer hacking statute. The Computer Fraud and Abuse Act, the CFAA, was enacted in 1986 to combat various types of computer crimes, including hacking. The law prohibits accessing a computer without authorization or in excess of authorization. Mr. Van Buren, a police officer in Georgia, was caught in an FBI sting operation using his authorized access to a license plate database to check the identity of a person for cash payment, an improper purpose. The officer was convicted and sentenced to 18 months under the Computer Fraud and Abuse Act. Though he appealed his conviction on the basis that the improper purpose was not exceeding authorized access, the 11th Circuit upheld the conviction based on precedent. This past June, the U.S. Supreme Court overturned the 11th Circuit decision and ruled that under the CFAA, a person exceeds authorized access when they access files and other content that are off limits to the portions of the computer system they were authorized to access. The opinion restricted the CFAA from applying to cases where a person obtains information from areas they do not have authorized access to, but uses that information for improper reasons. The Supreme Court's decision represents the first significant narrowing of the federal anti-computer hacking statute. Good arguments over the public interest implications were made on both sides of this case. Today, joining us are two amici brief filers in the case, representing the differing viewpoints on the statute. Gabe Rottman is from the Reporters Committee for Freedom of the Press, which integrates legal, policy, and public education efforts to protect news gathering and First Amendment freedoms as they intersect with emerging technological challenges and opportunities. Gabe serves as the project director of the organization's Technology and Press Freedom Project. Gabe came to the Reporters Committee from PEN America, where he opened the organization's Washington, D.C. office and served as its first director. He also was the deputy director for the Center for Democracy and Technology's Freedom, Security, and Technology Project. At CDT, he led efforts on cybersecurity policy and worked extensively on electronic surveillance and the rights of security researchers. Previously, Gabe served as the lead federal legislative and regulatory counsel at the American Civil Liberties Union on open government, press freedom, and the First Amendment. While at the ACLU, Gabe directed federal advocacy on the Espionage Act and its implications for journalist source protection. Gabe is a frequent commentator on technology and civil liberties issues, has been published in the New York Times, Washington Post, and testified before Congress. He has a joint honors BA from McGill University in political science and history and a law degree from Georgetown University Law Center. Megan Iorio is counsel at the Electronic Privacy Information Clearinghouse, EPIC. EPIC is a public interest research center in Washington, D.C., and was established in 1994 to focus public attention on emerging privacy and civil liberties issues, and to protect privacy, freedom of expression, and democratic values in the information age. Megan works on EPIC's litigation projects and leads EPIC's amicus work as its amicus project director. She has filed amici briefs on emerging policy, privacy, and technology issues in cases before the U.S. Supreme Court, federal appellate courts, and the high courts of California and other states. Previously, Megan was the organizing director of Just Foreign Policy, where she led grassroots campaigns promoting progressive foreign policy reform. Megan graduated from Georgetown Law, where she was public interest fellow, and she received her undergraduate degree from New York University. So in terms of today's format, we ask that you use the question and answer feature to ask questions throughout the presentations, and we'll collate them and get them answered in the last 20 minutes of the webinar. So each speaker will talk for about 15 minutes first, and then we'll go to the question and answer section, but just ask your questions throughout the entire webinar. And with that as our background, let's jump right into this to the discussion. Gabe?
Sure. Thanks so much for that introduction and for having me today. I don't know if I'm going to fill a full 15 minutes, but I'll try. Maybe I'll go long. But I was just going to initially cover sort of why the Reporters Committee for Freedom of the Press was interested in the Computer Fraud and Abuse Act in this case, and interested in these issues more broadly. The easiest answer is a lot of journalism today is being done, online. There's an emerging field of data journalism, and to put things sort of pretty simply in terms of what data journalism looks like, it's taking kind of the elbow grease journalism of what you would have seen, in the analog past. And translating that into the digital space using tools that make that make that journalism faster, that make it more effective, and that make it easier to gather significant amounts of data in effective and usable ways. And one of the tools that data journalists use is scraping or spidering, which is basically just the automated collection of data online. And that's quite a prevalent activity. As I say, that type of activity, goes back. There's a long history in a lot of the material that we prepared around the Computer Fraud and Abuse Act. And one of the sort of driving concerns that the Reporters Committee has with the way that the law is currently written is, there was the Atlanta Journal-Constitution had a landmark, series, back in the 80s involving involving mortgages and the provision of credit to folks. And it's one of the first examples of the kind of systematic data journalism that you see routinely today. But that series, called The Color of Money, led to significant changes to the Fair Housing law, and actually finally gave it teeth. And part of what the journalist in that series of stories was doing was going around physically to banks, to government agencies, and collecting information. And then collating that information and using it to report on possible housing discrimination and disparities in the Atlanta market. If you were to have a similar series today, that series would undoubtedly be relying on some form of data journalism, and indeed it could rely on scraping and other automated processes to gather that information. So that's the policy framework that presents us under the Computer Fraud and Abuse Act, and it's why the Reporters Committee filed an amicus brief in the Van Buren case, as well as the markup filed one as well. And specifically, what those amicus briefs are responding to is the interpretation of the statute. The Computer Fraud and Abuse Act has two sort of important triggers for possible liability. One is when you exceed protected computer, and protected computer now means basically anything connected to the internet without authorization, and if you exceed authorized access to that computer. In the Van Buren case, the question that was before the 11th Circuit, and it answered this question in the affirmative, was if you access a computer with authorization, but then you access information that you're entitled to access in that computer, but you do it for a bad reason, is that a violation of the Computer Fraud and Abuse Act? And putting aside whether it could be a violation of other laws, that was the question that was before the 11th Circuit, and they said yes, relying on precedent in that jurisdiction. The Supreme Court in the Van Buren case, it effectively said that there's the way that the statute is written, and I won't get into too much of the nitty gritty in terms of the statutory language, but the court basically found that if you were to adopt the 11th Circuit's interpretation, which is that anytime, even if you have access to the computer with authorization, so it's your work computer or you borrowed a friend's computer, whatever it is, that if you were to interpret the language of the statute in a way that accessing information that you had authorization to access on that computer, but you did it for a bad reason, that would encompass and the court said, breathtaking number of instances of folks using computers in ways that they weren't permitted to do so. And the part of the part of the problem there, and again, one of the reasons why the Reporters Committee and other amici were concerned with the government's position in this case and the 11th Circuit's decision, it wasn't so much around the specific facts of this case. It goes to, and this is particularly true, I think, for press freedom advocates. When you have language like that and it's unclear as to whether it means using a computer, using information that you otherwise can access in a computer, I have I have a permission to go into folder A in a computer and access the information there, but I don't have permission to go into folder A and access the information for a purpose other than X or Y, that permitting that kind of vagueness in a federal law like this could lead to arbitrary or selective enforcement. And when you're talking about statutes that could possibly be used to interfere with news gathering or other First Amendment rights, imprecision like that and the possibility of selective enforcement is always of great concern. And when you're talking about journalists who are reporting on government entities or others who can effectively set the terms of what information they can gather through the CFAA, that danger of arbitrary or selective enforcement is heightened. The Reporters Committee is also, we filed an amicus brief in another case called HiQ v. LinkedIn. That case was remanded back to the 9th Circuit after Van Buren, and that deals with whether scraping publicly available information from a website can state a civil violation of a civil or criminal violation of the CFAA. In that case, it's a civil case. But the fundamental issue there is the same, right? That if you're a website or a website provider and you make information available to the public, but you say you can't access this information for this or that purpose, that you're creating that possibility of arbitrary or selective enforcement that could chill speech. We also filed in another case that I think kind of highlights some of the dangers in the way in which the CFA could be interpreted and utilized by government officials. There was a case in called Friends of Fullerton versus City of Fullerton. It was a California state case and involved a blogger, who was engaged in litigation with a city, public records litigation with the city. And they were sued by the city for allegedly accessing a publicly available Dropbox folder that didn't have permission to access. And the suit claimed a violation of both the federal CFAA and the state, the California state analog. And that's the kind of so in that case also was resolved with a settlement, and the blogger ultimately prevailed in the case. But it's that kind of concern that leads to groups like the Reporters Committee and others being concerned with the interpretation that the government put forward in this case. I'll just say one last thing on that point in terms of the government's interpretation here. The Computer Fraud and Abuse Act, it applies. So first of all, it's both a criminal and a civil statute. And if the private entity is able to set the terms of how one can access information to the purposes by which you can access information in a computer that you're entitled to access, it delegates the metes and bounds of the statute, what it applies to the private parties. And that's not a great thing for again, especially news organizations who are often reporting on actors in a way that those actors may not entirely appreciate. And if there's a tool that those actors could use to try and stanch some of that reporting, they might try and do so. So I think I'll leave it at that, because I think there's going to be Q&A coming in. But again, fundamentally, the issue is in the Van Buren case and also in HiQ, whether it's appropriate to have a law like this, as opposed to an actual hacking law that gets at using technological means to bypass access restrictions. If you have a law that otherwise gives a public or private party the ability to dictate what the violation of the law is, you're asking for possible arbitrary enforcement, and that's of constitutional moment here. Thanks.
Thanks very much, Gabe. Appreciate hearing where the Reporters Committee is coming from on this issue. Megan, you want to take the floor and talk to us about EPIC's view of the case?
Sure. First of all, thank you for having me. I'm Megan Iorio from the Electronic Privacy Information Center. As our name suggests, we're concerned with, we're a privacy organization, so we're concerned with the privacy interests of individuals. And we first got involved in the CFAA through the HiQ v. LinkedIn case. And actually, initially, we didn't touch the CFAA in our initial involvement. What we got involved in was on the HiQ had filed for a PI, a preliminary injunction against LinkedIn to force LinkedIn to give it access to its user data again. And the public interest prong of the PI talked about mostly the interests of corporations and not the interests of the users whose information was being scraped. So we got involved to represent those interests. And then we started going down the path of issues with data scraping. And in particular, an event that happened since we initially got involved in the LinkedIn case is Clearview AI, which used scraping to create a massive facial recognition database. And so, we're concerned about two groups of people. And one is the one that I was just describing. It's internet users whose personal information is online somewhere and has either been scraped or can be scraped by unexpected third parties. And often they're collecting this information against the user's interest. In HiQ's case, they were building a system that scored employees for their employers, for instance, telling their employers when the employee might leave their job. And again, Clearview AI creating a biometric database. And our position is that from a policy perspective, that internet users shouldn't have to choose between, using popular web services, having a web presence, and then being placed in a facial recognition database, or again, being scored for their employers or for creditors by their web presence. And then there's another group of people, and that's people whose personal information is in these massive commercial or government databases, aggregation of loads of personal information by data brokers, often from the internet, or tracking people's internet activities. And then you also have many databases with highly sensitive data, such as biometrics, and employees who have access credentials, but they still pose a security risk, which is why government agencies, like the one that Van Buren was in, do extensive training and have policies for when employees can access records within a database. So we got involved in the Van Buren case because we thought that Van Buren's conduct was within the scope of the exceeds authorized access prong. And that's because what I was just saying about, he was accessing a record that he never had authorization to access. He had a credential to the database, but was never authorized to open that particular record. We didn't think that the policy at issue there was a use policy, many other things. And we also thought that there were ways to cabin the CFAA, coming into it a little fresher than other organizations that have been involved for a very long time, and who have gotten behind the code-based versus non-code-based distinction, or the logging gate versus no logging gate distinction. We thought that that didn't fully capture the scope and variety of data protection methods that can and should be legally protected. So, obviously the Supreme Court didn't adopt our way of interpreting the CFAA, but one important outcome, I think, from Van Buren is that the court's main concern was to distinguish between access restrictions and other types of restrictions. That is why they adopted this gates up or down metric, because they saw that a restriction that says you can always access something or never can access something is obviously an access restriction. Might not be what we preferred to have been the outcome, but it does do a lot to narrow the statute, and in ways that especially cabin concerns with terms of service violations. So because access can't be conditioned on certain conduct, then accepting terms of service and violating them does not mean that an individual has automatically violated the CFAA. Something else needs to happen. But the case still left a lot open. And mainly it left open all the other aspects of what it means to be authorized to access a computer and to access information. And it explicitly left open what methods a computer owner can use to either grant or deny authorization. They could have adopted Oren Kerr's theory of the logging gate, or they could have adopted the technological barrier. They didn't. So it's still up in the air what websites can do to restrict access. Under Van Buren, it's not clear whether a website can have a pop-up, let's say, that says only people over 21 can access the site. And then if you're under 21, can they pursue a claim? They should be able to, but Van Buren didn't answer that. And then just want to quickly note that the next big test for the CFAA is going to be HiQ v. LinkedIn. This is, the previous decision was vacated. Like Gabe was saying, it is entirely based on this kind of carve out for publicly available information. My interpretation of Van Buren is that the Ninth Circuit's going to have to rethink that carve out, because people are either authorized or not authorized to access a computer. And so if people are allowed to access a website by default, then they're authorized. So the question becomes, well, there are two questions the court's going to have to directly confront. What must the website do to revoke access to information that's made available to the general public by default? The Ninth Circuit can say they have to put it behind a login gate and it would be a similar outcome as last time, or they can do something more nuanced. And then they have to directly confront whether LinkedIn did revoke HiQ's access to the website. And I'll leave it at that.
Thanks very much. I've got a question to get us started. I'm wondering how, if this precedent that we saw this summer from the Supreme Court might have impacted the prosecution of Aaron Swartz nearly 20 years ago. For those of you who aren't familiar, he was the young MIT computer programmer whiz kid who was being prosecuted under this act for making information that he obtained from his school's internet access available to others. And he ended up committing suicide. And a lot of people thought it was, because there was this really heavy-handed aspect to this law that was just enabling overreach by prosecutors and others. So I'm wondering if the panelists think that, had a precedent like this come before, would he have been safe from prosecution?
Megan, I don't know if you want to. It's a great and very sad question. In the Aaron Swartz case, I think one of the big issues there was overcharging. Was stacking of charges in a way that would in a way where an individual was placed in a very untenable position of trying to plead or take their chances at trial. And the overcharging, I think in that case is what people have really pointed to as a problem. But again, it also goes to the part of the issue with the CFAA is inherent, as I say, vagueness, and that vagueness, part of arbitrary or selective enforcement issues with statutes is prosecutors can use them to go after individuals in a way to make an example, and with the journalistic sources can face issues like that when it comes to things like the Espionage Act and other federal spying laws that could potentially implicate news gathering. So it's that arbitrariness that the Supreme Court was getting to, and I think also there's been a significant amount of advocacy and attention paid to the potential issues with the Computer Fraud and Abuse Act, and so maybe there would have been more more attention paid if that case had come up now, and more circumspection in terms of the charging decisions made.
I think I can't remember exactly what policy Aaron was supposed to have violated, but I think that if you were on MIT's campus, you could access their Wi-Fi and you could access JSTOR. So it seems like this decision may have kept him out of the scope of the CFAA, but like Gabe was saying, it was this, the stacking of criminal charges on criminal charges. It was not just the CFAA that was the issue there.
Thanks very much for that. We've got a couple of questions from our attendees. The first one is from Jessica Dickinson Goodman, who asked a somewhat similar question. To what extent could selective enforcement of this statute have impacted former Treasury Department official Natalie May Edwards' work as a whistleblower in the FinCEN files investigation from BuzzFeed News?
I can jump in on that. So that's a very interesting question. So the prosecution, that prosecution is violations of bank secrecy laws, right? She was alleged and pled guilty to disclosing suspicious activity reports, which are filed by banks with the Treasury Department. And what's interesting about the question you raised is it's not a CFAA. Well, so if the question is under the government's interpretation of the CFAA that it urged the court to adopt in Van Buren, then if she had authorization to access those SARs, those suspicious activity reports, but then did so in order to leak them, that could be a violation of the Computer Fraud and Abuse Act. Under the Supreme Court's interpretation in Van Buren, that's much less clear, and it would depend on how her access to those SARs was actually structured, like actually in the network and computer system. But it raises an additional point, which I think I sort of alluded to, but the Computer Fraud and Abuse Act has also come up in a lot of the journalistic source prosecutions that you've seen, since 2009, for what are colloquially known as media leaks. And the CFAA itself raises some of the same concerns as the particularly the federal spying laws, the Espionage Act and others, and how they can be used in a selective way. So your question is a very good one in terms of how the CFAA could apply, to what was alleged in that case, but it also highlights that additional concern with the CFAA.
All right, thanks so much for that. We've got another question from Jessica. Is there any current federal legislation to fill in the gaps that you just identified, like websites requiring people to certify they were over 18 or in a certain country, et cetera? Any federal legislation?
I don't believe so. To exempt that kind of. No, I'm not sure of any legislation that has to do with those particular examples. But I know on both sides of this debate, there's support for data protection legislation at the federal level, which could fix a lot of the nuanced problems with CFAA, and that also support for requirements for transparency from companies such as Facebook, so that maybe that scraping is not relied upon as much to obtain information.
Okay, thanks. Jessica's got a follow-up question. What might federal legislation look like if there isn't any pending? Do you have a wish list?
The wish list is very long. If I had to, from scratch, create a new law, let's say to protect individuals from harmful web scraping, perhaps I would do something along the lines of targeting it toward collection of personal information instead of any kind of information, and to scope it along the different either uses or purposes, to allow for such things as research and security work. But often the retort is, well, we have the First Amendment in this country, and so if information is publicly available, then everybody has to be able to collect it freely. We don't accept that, and the First Amendment allows for distinctions to be made among purposes, uses, if there's a strong enough reason for it. And I think Clearview AI is a pretty strong reason for having some kind of restriction on scraping of personal information on the internet.
Thank you. Gabe, do you have a wish list of federal legislation you'd like to see along these lines?
Along these lines, I mean, in terms of legislation that would address the Supreme Court's decision in Van Buren, I don't think we would take a position on that. I'm not aware of anything that's been introduced, but it's possible there is, to respond to the decision. From our perspective, I think the laws like the CFAA, and there are others, that if there was a way to add precision, so there wasn't as much uncertainty in terms of their application, would be significantly helpful for journalism, for the free flow of information, and so those are the kinds of things that I think we would be looking at.
Great, thank you. I don't see any other questions right now, so if folks want to type some in, we can get those answered. In the meantime, do our panelists have any final last thoughts, points to make on this case?
I guess I would just say, again, part of the part of what is happening, I think, in the Van Buren case, and it's a dynamic that I don't think is limited to. I mean, it's not limited to Van Buren. It's not limited to the CFAA. One of the things that was one of the arguments that the government made in particular in the Van Buren case was, we will use, and the DOJ has made this argument routinely, is that we will use our discretion to apply this law in the right way, and it's an argument that we've seen in other. Again, I keep coming back to the leak context, but the CFAA is directly relevant to those issues as well, and the Supreme Court said that when you've got a statute like this, I mean, really, the other thing too was that the reading of exceeds or the reading of accessing a computer without authorization, and then exceeding authorized access, which really in the statute means obtaining information that you're not obtaining, or altering information that you're not entitled to obtain or alter. The Supreme Court said that the logical reading of the definition of exceeds authorized access and the way that it works in the statute was a narrow construction. That really what you're talking about is this gates up or down, test, both with accessing a computer without authorization and in exceeding authorized access. But the court was also troubled by the breathtaking array of possible applications of the law if you were to adopt the government's argument. And the government's argument in the case kind of came down to, again, trust in our prosecutorial discretion. And that goes so far, but it also, when you're talking about laws that could potentially impact First Amendment activity, either by suppressing that activity by targeting it through a civil lawsuit or a criminal prosecution, or stopping it from taking place in the first instance because the person's concerned about what the scope of the law could be. The court said that when you're talking about the First Amendment, those considerations, particularly in the vagueness doctrine that I've been talking about, counsel against giving the government, an undue amount of discretion in terms of how the law can apply. That I think is a valuable, I think was a valuable thing that the court did there, and an appropriate recognition of when you're talking about, if you're a newsroom lawyer and a journalist comes to you and says, I want to do X or Y, is it okay? And you as the lawyer are kind of unable to answer that question with some degree of confidence, and the possibility of either civil exposure or a criminal prosecution, leads the reporter not to do something, that we want to make sure that that's happening as rarely as possible. So, and I think the court, I think the Van Buren decision recognizes that dynamic or that concern.
I'd also like to ask about the protection of whistleblowers. A lot of them get caught under the CFAA, but not. There are other laws as well, and we know whistleblowing is a really important public good that we need to protect, but it's not easy to define. And so I'm wondering what panelists thought, if you had any recommendations for how we can protect whistleblowers going forward with CFAA and other laws.
Gabe.
So this gets back to kind of what I was talking about earlier, which is how laws like the CFAA can be used in a way that is selective. It is selective in order to get at speech that the government doesn't like, or that in this case a private entity doesn't like. Again, it comes down to the most important thing is that when the First Amendment is at play, precision is the watchword. And the history of the CFAA is one of kind of tailored application in a way that made some sense in terms of preventing hacking of sensitive government systems, and it was expanded and expanded and expanded. And now what's at issue is if you access any protected computer, so any computer that's connected to the internet, and you do so without authorization, or you do so in a way that exceeds authorized access, which means that the definition of those terms, the meaning of those terms, needs to be as precise and understandable for any computer user, as possible. And ultimately, the gates up or down. There's discussion about, and we've touched on this before. Does it need to be some kind of technological override, right? Where you're, cutting through a password gate, or, installing malware in order to bypass some like clear access restriction in code. But ultimately it comes down to that whatever that is, whatever that thing is that triggers potential liability under the statute, we need to know what it is. And the court did the court in Van Buren has given us some of what that is. But if you want to talk about protecting individuals who are disclosing government information, what's key is that you have that precision in the law, so that you know what steps over the line and what doesn't. That's the way that you would want to cabin the scope of the law in order to protect individuals like that.
Great. Thank you very much. I don't see any more questions here, so I think we can draw this session to a close. And I want to thank you all for attending, and especially big thanks to Megan and Gabe, who came and talked with us with this really interesting information today. And I'd like to invite you all to join our next session next month, which will be October 4th at 3 p.m. And it is a case involving an organization called NetChoice, together with the Computer and Communications Industry Association, CCIA, who have filed a lawsuit against the state of Florida after Florida passed a law banning social media platforms from being able to regulate the speech on their platforms. And this was done in response to the former president being deplatformed from Twitter and Facebook. So Florida fired back by saying, well, you're not allowed to do that anymore. And so these two organizations, NetChoice and CCIA, they filed a lawsuit against the state of Florida to enjoin the enforcement of this new statute. And they won at the district court level, and the state of Florida has appealed that to the 11th Circuit. And so that's currently pending before the 11th Circuit. And this is a very important case for freedom of expression on the internet in terms of what internet users are allowed to say about politicians, and what platforms are allowed to, the kind of regulation of their systems. Are they allowed to have terms of service that they can enforce? So this is a very important case for internet free speech and for technological innovation. And we'll be talking about that case next month, October 4th, 3 p.m. Pacific time. So I hope you all will join us then. And again, a big thank you all for attending, and thank you to our speakers for today's presentations. And I hope you all will consider joining our chapter. Thank you very much. Goodbye.
Thank you.